Third case, as council begin to move their positions, the third and final case is 24-1910, Gregory Williams versus Leesburg Regional Medical Center et al.
Thank you, Your Honor.
Thank you, ma'am. All right. Counsel for Mr. Williams, 5 minutes for rebuttal, or how much time?
Yes, sir.
5 minutes, all right, sir. You are welcome to proceed.
Thank you. I'm Adam Richardson. I'm here representing the appellant who was the plaintiff in the trial court. Here, the trial judge struck each of our causation experts on Daubert grounds and then, as a result, granted summary judgment. We're, of course, asking the court to reverse the judgment and the striking of the experts and allow this case to proceed to trial. Under the trial judge's apparent standards, an expert would have to be the world-leading expert or close to it in a very specific area and have unequivocal support for their opinions in order to testify. That's not the standard. It's never been the standard, and that's clear from many decisions across the country that we've cited in our briefs. All an expert has to do is have an expertise in a general area. I'm sorry, did you have a question, Judge?
No.
Okay. An expertise in a general area, and even if they don't have experience with that specific, usually a disease process or a product, they can still be rendered qualified as an expert to testify on it. They also don't even need to have any textual support, depending on the case. For example, in this case and in others, when it's unethical to conduct what is the gold standard of blind clinical study, the courts have held that it's not necessary to rely on that kind of evidence. We can rely on epidemiological evidence, for example, retrospective observation studies, reviews, case series, reports, which are typically not as reliable, but under the circumstances, still accepted as reliable data to support an expert opinion. Here, our experts did have textual support. They were able to cite different medical authorities. Dr. Snow and Dr. Rimawi, in particular, were able to cite between 8 and a dozen authorities, all of which supported their opinions that had the infant Madeline been administered a macrolide antibiotic, such as azithromycin, when she initially presented to the defendant hospital on March 31st, she would more likely than not have survived and not died.
Wasn't Dr. Rimawi unable to say how far into the first stage, I'm not going to attempt to say the names of the stages, but all the experts seem to agree that at stage 1, antibiotics could be helpful, but if it's too late into stage 1 when you're going into stage 2, then that may not have been helpful, and he wasn't able to determine how far into stage 1 she was. I believe he referenced white blood cell counts and something like 30,000. If her white blood cell count was that high, that would have been too far gone to administer antibiotics to have made a difference.
Yes, but I think in general, the literature supports the proposition that in general, in the cartaral phase, which is that first phase, had macrolide antibiotics been administered when she presented or shortly after she presented, that more likely than not she would have survived. The severity of the disease would have gone down, perhaps duration of symptoms, and it would have affected, for example, the white blood count, even though it was elevated at that time. I think Dr. Ramawi, but more particularly Dr. Snow testified that it's the bacterium. The macrolide is not a toxin-mediated antibiotic. It targets the bacteria. And so
Wasn't that part of the problem, that we didn't know the effect of the antibiotic? We knew that it affected the bacteria, but we didn't know what the level of toxins were to make any difference in the progression of the disease.
And that's where we go back to the general law in this area, where the expert doesn't even have to conclusively establish a link, a causal link between a particular, like usually again, it's a disease or a product, and the outcome. All we have to know is that there's somehow a relationship, there's an association. Here, I'm sorry.
Well, the issue, right, is the admissibility of the expert testimony. And Daubert's there as the court acts as a gatekeeper so that you don't have someone coming in from the witness stand with that aura of reliability that just because they're an expert and says, yeah, if we had given these antibiotics at this certain point in time, that would have made a difference. So looking at the trial court's decision, aren't they saying, how did you get to this conclusion? And if it's just this general principle that antibiotics that are given earlier improve results, then how does that help the jury determine at what point did the antibiotics need to be administered in order to make a difference?
So that's the straw man that the defendants relied on. Earlier is better. I categorically refute that. It is not simply earlier the better. Here, they relied on their training, their experience, and the medical literature to say, if this had been administered in a specific stage, not in general, earlier is better, in a specific stage, more likely
Of the
than not,
disease
yeah.
progression, right? But you had, I believe it was Dr. Snow talking about the difference between presenting infants versus adults. And I think the majority of the experts, if not all of them, talked about how rare the presentation of pertussis is because of the prevalence of vaccines.
Yes, I think that touches more on standard of care, whether they would have, whether Dr. D'Amato would have recognized the symptoms and made a timely diagnosis. Here, we're focused only on causation. And when the cases talk about that, establishing the causal link, they also they account for the rarity of the disease. So again, we don't have to conclusively establish the causal link between pertussis, the administration of a macrolide antibiotic and avoidance of death. We just have to establish an association with it. And we did that by providing, our experts did that by providing over a dozen medical literature articles supporting
So
that
the standard of
association.
care would be separate in whether the doctor should have known to do that,
Yes.
right? But then the causation is what would have been the impact?
Yes.
At what time? And so I bring up the lack of prevalence of, thankfully, of infant mortality with this disease to say, for example, if you're relying on experience, Dr. Snow testified that she treated 4 infants in 18 years. You can certainly develop, maybe I'm misreading that, that was what I wrote down, and I believe only 1 had passed away. So if you're relying on experience, it has to be enough experience that you can develop a reliable methodology for reaching that conclusion.
Yes, so I'm very respectfully going to correct that.
Go ahead.
Okay, so Dr. Snow in her 18 years has treated around 8 to 10 patients with pertussis, some of whom were under 90 days, like Adeline here. And then Dr. Romamwe has said that in his experience, his practice, he's treated around 30. Now, given the this is where I think rarity actually helps us. So how many pertussis cases in infants who are unvaccinated should an expert have to, or purported expert, have to have treated before they're sufficiently qualified or are able to use that experience to have a reliable opinion? And when a disease is that rare, I think it's not what Daubert contemplates to require some like hundreds or something of cases. Now, maybe a world-leading expert would have hundreds of cases of child pertussis, but the Daubert cases don't require you to be world-leading. I understand that Daubert makes the circuit court a gatekeeper, but at bottom, it's not a very high threshold because the Daubert principle is still flexible. It counsels for admission, and then a lot of the things that my friends on the other side, their quibbles with these experts are really for cross-examination. So, for example, what would defense counsel ask Dr. Snow at the trial? Well, but do you know for certain whether the administration at this point, late in the catarrhal phase versus the early catarrhal phase, would have impacted the outcome? Then Dr. Snow or Dr. Wimamwe would give that answer, and then it would be up for the jury to decide whether that's a credible answer or not.
What was the basis of, if they were answering that question, what data or methodology would they be using to come up with that?
The very standard clinical methodology that they use in their practices, which is they have the facts. Here, because it's expert, they would be gathering it from primarily the medical records of the infant. Then they would use their clinical, their training, education, and experience, all of which they testify to at length in their depositions, along with the medical literature that they found and reviewed and also went in detail in their depositions, to then render an opinion. And kind of when I think about Daubert, it's because we have to prepare our experts for it in the trial courts these days. I think of it like, way back in law school, IRAC, issue, rule, analysis, conclusion. What's the issue here? Causation. What's the rule? Well, we have their experience, their training, and the evidence provided by the medical literature, and then they just apply it and then reach a conclusion. And that's a very reliable methodology. It's what they use in their practice. It's what they said they use in their practice. And it's not necessary to go through this whole, rigmarole of clinical trials, peer-reviewed testing, stuff that you would, I think, find appropriate to require in other cases. Primarily because, again, this is a rare disease. You're not really going to have clinical trials. At best, you're going to have retrospective observational studies, which our experts did find and proffer and explain in their depositions. So it's not a Herculean effort that our experts have to endeavor in to satisfy the reliability standard. In fact, some of the cases from other federal circuits talk about they just need reasonable grounds for their opinion. And what are reasonable grounds? Exactly what I've just talked about. You have the facts from the medical records, you have training experience, you have medical literature. Then they explain how their conclusions follow from all of that. Here, the trial court usurped the role of the jury in making some of the credibility determinations and weighing the different points that counsel made in their discussions with the experts during the depositions. But most of that should have gone directly to the jury, and if they really want to challenge the opinions, they can challenge the opinions, the conclusions. And it's kind of difficult. I said in the briefing that the trial judge kind of used a mishmash of reasoning in the order. I have a little bit of difficulty following it, but reading between the lines, I think what the judge actually did was contest the conclusions. He simply, I think, felt that the conclusions weren't believable or credible.
Well, he also addressed relevance, right? So the central question is, at what point in the disease progression would antibiotics have made a difference? So what was the opinion of any of the doctors that would have helped the jury to decide that issue?
Their opinions that would have helped were, because this is a stage disease, that it would have been in the catarrhal phase. So,
and how did they decide what phase the infant was in on March 31st?
So on March 31st, she presented with, I think it was, the primary thing was coughing. It was kind of, I think in the literature would be referred to as grunting. And when you...
That was on April 1st, right? The first day she didn't present with that.
April 1st was different. April 1st was the paroxysmal coughing, which is the typical whooping cough. And so they noted from the medical history on April 1st that was the first time that was documented in the medical records. That's what the mother said. And earlier it was what should have been recognized as the symptoms of pertussis in the catarrhal phase, which is, again, primarily like coughing. Typically, like the experts said, there's no fever in children in pertussis, but they said more likely than not, within a reasonable degree of medical certainty, that this child was in the catarrhal phase. And that's, again, something that the jury should be able to decide. The jury should be able to decide whether, based on the facts that they have and their credibility at trial, whether they're believable, whether the child was in the catarrhal phase. But to cut off the case at the Daubert stage because of something like that really mistakes what the Daubert inquiry is supposed to be. The Daubert inquiry is screening out junk science, bogus science, some of the cases say. I don't think you can look at any of these experts and say that this was just junk science.
Well, the junk science really goes to the reliability prong, right?
Yes,
There's
ma'am.
3 different questions. Are the experts qualified? Is their opinion produced by a reliable methodology? And then, is it relevant? Is it applicable to this particular case?
Yes. So I think the question you had asked before was whether it assists the trier of fact, helpfulness, and relevance.
Mm-hmm.
Okay. Again, I go back to this straw man of earlier is better. In cases, like the case that they rely on the most is McDowell, which is an 11th Circuit case. And there, the 11th Circuit went into quite a bit of detail into the expert testimony. And if you review the opinion, literally, those experts, all they had was earlier the better. They couldn't testify as to any kind of timing. They didn't have any real medical literature. And in that case, I think, yes, it's appropriate to say that that wouldn't assist the trier of fact because it's just common sense. But here we have a lot more than that. We have the facts in the medical record again. We have their explanations of how pertussis works, how it progresses, literally how it works in the lungs and the airways they testified to. Then their explanations of their experience with pertussis, pediatric pertussis cases, and that's particularly Dr. Snow and Ramwanwe, who I will be very forthright are our strongest experts. We're not making a claim that each expert is strong. You know, it was up to the court's discretion to go expert by expert and determine which is sufficient or not. And then make a conclusion. So it's not simply a conclusory statement that the earlier is the better here. They have 140, 170-page depositions going in great detail into their opinions. And I know that the defendants tried to really get them on the earlier is better. I know the trial judge accepted that, but it's not a fair reading of the depositions or their opinions. And with that, I'm going to reserve the rest of my time for rebuttal.
All right, sir. Thank you very much. Counsel for Appellee, will one counsel be addressing the court? Are you going to divide the time? What's your intent?
We're going to attempt to divide the time, but we're not wedded to that. If I end up taking more time, then that's fine. If there's some time left over, then Ms. Phillips is going to talk.
All right, so you all have worked that amongst yourselves. All right, you're welcome to proceed.
May it please the court, Christine Davis on behalf of Leesburg Regional Medical Center, and as we mentioned, Jennifer Phillips on behalf of the co-appellees, Dr. De La Mata and Paragon Emergency Services. The trial court here did exactly what it was supposed to do in its gatekeeping role. It determined the scientific reliability of the experts' causation opinions, and it determined whether the experts were qualified to render those opinions. On this record, it can't be said that the trial court's decision was manifestly erroneous or that no reasonable judge could have reached the same conclusion as this trial judge. So starting with the medical literature, which is what was a focus point of the hearings below, none of the medical literature the experts cited provided reliable scientific support for their conclusion that had antibiotics been given on March 31st, when this infant was in the very last day of the catarrhal stage, which is not early in the course of the illness, as they all admitted, probably would have caused this infant to survive. The literature says is that antibiotics administered early in the catarrhal stage, early on in the illness, can or may lessen the severity of the symptoms or reduce the transmissibility to others.
How do you respond to the argument that it's rare to have these cases of pertussis in infants? So that makes, I guess, gives them more leeway in applying the data to these facts.
I disagree with that somewhat. I don't think pertussis is rare. I think they have so many articles on pertussis, you can tell by all of the studies on it, that it happens. What makes it rare is that there's a vaccine, so less people get it than used to. But so I don't think that they can sort of hide behind, this is rare, so we get to rely on something that's not reliable. And none of the literature here, importantly, said anything other than giving antibiotics in the catarrhal stage will lessen the severity of the disease. So you can't do studies on infants. You're not going to withhold antibiotics. You could have, there's, I think, more than 1,300 infectious pediatric disease doctors board certified in the country. You could have an infectious disease pediatric physician who deals with these things on a regular basis and has treated infants regularly, or even adults, with antibiotics, and has been able to determine the time at which that administration makes a difference on the clinical outcome. None of that was presented here, and none of those articles none of the articles that they rely on support that conclusion. What the plaintiffs, experts in the plaintiff's argument attempt to do is draw an arbitrary defining line between catarrhal stage, paroxysmal stage. And just because antibiotics are started in the catarrhal stage means more likely than not you'll survive, and when you start it in the paroxysmal stage, you won't. We're talking, we know that this infant was in the very last stage, and that and everyone agreed that had she been given to everyone but Dr. Pinkowski, which he just said he isn't relying so much on, but everyone agreed that giving it in on the paroxysmal stage the next day would have made no difference. So the trial court here correctly found an analytical leap that wasn't supported. It was medical literature that says, treat it early in the catarrhal phase, and you'll lessen the severity of the disease, and you'll lessen its transmissibility. Then you had to leap to an entirely unsupported conclusion that giving it to an infant or any individual in the very last day of the catarrhal stage would have been the difference of whether this infant lived or died. And the literature simply just does not support that. And then, Judge Blocker, you mentioned the difference between eradicating pertussis bacteria and eradicating the toxins. And all of the experts acknowledge that those are two different things. Pertussis is a toxin-driven disease. So what causes death in people with pertussis is that the toxins lead to an extremely elevated white blood cell count, and that leads to pulmonary hypertension and death. And of course, Dr. Snow and Dr. Ramawi did not, you could tell from their depositions, did not fully understand how that worked, but they did acknowledge that toxins caused the death, and that they didn't know, and that antibiotics only dealt with eradicating bacteria. So even though the medical literature supports a conclusion that pertussis bacteria would be eradicated, it doesn't support the conclusion that the toxins would be eradicated, and therefore the outcome would have been different. And the facts of this case, because there has to be a reliable fit between the opinions and the facts of this case, and there is no fit here. So we know that on April 1st, when the infant arrived at the hospital, her white blood cell count was extremely elevated at 58,200 and quickly went up to 61,000 that afternoon. And the experts, even plaintiff's experts, agreed that the infant's white blood cell count on March 31st, when she first arrived at the hospital, would have been extremely elevated. Dr. Ramawi estimated that it would have been between 38,000 and 43,000. The medical literature they rely on makes clear that most pertussis cases are fatal. The vast majority of them are fatal when your white blood cell count is above 30,000. So we know this infant, when she came on the very first day, had an extremely elevated white blood cell count. The pertussis toxin was already very much infiltrated into her system. And so there was no reliable scientific evidence that had antibiotics been started on March 31st, that she would have survived. And the literature certainly doesn't support that. Moving to the qualifications, we only had two things here. Council mentioned that Daubert is a flexible standard, and it's a flexible standard in the sense that you're not limited to what the courts have said, Daubert, Joyner, and a lot of 11th Circuit cases and some Florida cases have said, this is what you consider when determining whether something's reliable. But it's not a rigid standard because depending on the facts of the case, you can consider other factors. It just depends on what you're dealing with. But it is, the court does have to apply a rigorous analysis. So it's not a liberal standard that you just let it go, err on the side of letting it in when the literature is unreliable, and especially when, on top of the literature being unreliable.
So where would you draw the line between rigor in your function in the trial court's function as a gatekeeper and depriving a plaintiff of the right to a trial by jury?
I think it would be what happened in this case would be a good example. Also what happened in Morgianos, which is cited in the briefs. That case talked about how there was, like here, an abundance of medical literature provided, and the court went through it and had to determine whether there was that analytical leap, whether there was a reliable basis. And so I think the rigor part of the trial court is to consider, okay, this is the medical literature I have. This is primarily what they're relying on. So does it reliably support? We don't want to send a case to the jury and ask them to choose between sound science and speculation. So the trial court's job as the gatekeeper is to make sure only reliable evidence gets to the jury. So you conduct that.
But how wide is that gray area? This is the line I always kind of spend a lot of time at in Daubert cases.
Yes.
Daubert, as our court recently acknowledged, Daubert itself cautions vigorous cross-examination, presentation of contrary evidence, and careful instruction on the burden of proof are the traditional and appropriate means of attacking shaky but admissible evidence.
Correct.
Where is that line?
I agree with you on that, and that's when you have shaky but admissible evidence, which is not even close to what we have here. We have medical literature that doesn't at all take the analytical leap that is required to reach these experts' conclusion.
Is the existence of litter a condition precedent to admissibility?
Not necessarily, but then you can have someone who has a significant amount of experience. I think the Dickinson case that is cited in plaintiff's brief goes through, when you don't have medical literature, you can have significant medical experience, or you can have other factors such as temporal proximity and other things that don't apply here. Here we have two things: medical literature and experience. That's what they relied on. Medical literature was not enough. And then we moved to experience. That was definitely not enough. Dr. Snow, while she said she treated 10 patients in her career, she specifically testified she was basing her opinion on the 4 infants she had treated that had pertussis. And her whole basis for that was because one of those infants was in the paroxysmal stage and died, and the others were in the catarrhal stage and lived. And importantly, those infants that were in the catarrhal stage were given antibiotics at the outset of the disease. She admitted that. They reached her under her care when they were becoming later in the catarrhal stage, but she acknowledged that that antibiotics had been started early in the catarrhal stage. So that experience is not sufficient enough to overcome the complete contradiction in the medical literature or the lack of the leap you can make from what the literature says to what the expert concludes. Dr. Ramawi is similar. He said he treated 30 patients with pertussis, but in his testimony, he didn't even know those patients had pertussis when he treated them. He said they came to him with extremely high leukocytosis, the high blood cell count, and he put him on an antibiotic. He only learned later when his colleagues told him that those infants ended up having pertussis. So maybe he's had some, fuzzy experience with pertussis in the sense that he put an infant on antibiotics because of a white blood cell count, and they ended up having pertussis, and perhaps they ended up living, which isn't even clear from his record, but that is woefully insufficient to have the experience required to reach this conclusion. So together, we have two things. We have the medical literature and we have experience, and neither one of those, in this case, provide reliable, sufficient foundation for this to go to the jury. So a lot of these issues, as you were saying, Judge Soud, can be handled by vigorous cross-examination, but only after the trial court has conducted the analysis to make sure that the foundation is reliable, because juries aren't equipped to make the differentiation between relevance and reliability. They can weigh credibility and weight, but they're not. The reason the judge is the gatekeeper and the reason the judge has to carefully evaluate the evidence before allowing it to get to the jury is so that the jury has reliable evidence, and from that, it weighs the credibility and weight. There's no vigorous cross-examination in this case that would have been sufficient because the medical literature simply did not support it. And I think there's a good quote in the Allison case from the 11th Circuit, and you mentioned it, Judge Blocker, during plaintiff's presentation, that jurors give more weight to expert testimony. Allison said used the words, they're awestruck by expert testimony because these are the doctors that are supposed to be reliably providing information, and none of these doctors, none of the experts in this case could do that because the literature simply required too great an analytical leap to reach their conclusions, so they weren't supported, and they couldn't back it up with their qualifications because they didn't have remotely enough qualifications to reach these conclusions. So we submit that the standard of review is obviously abuse of discretion. No reasonable judge could have decided this. It shouldn't be overturned unless it's manifestly erroneous, and that standard is certainly satisfied here, so we ask that you affirm.
All right, thank you.
Good afternoon, Your Honors. May it please the Court. Jennifer Phillips on behalf of Dr. Delamata and Paragon. And I just want to touch on a few things because Ms. Davis did an awesome job of describing our position. I'd like for Your Honors to consider this case in terms of what the plaintiff is alleging, that the ultimate conclusion that they have to reach in order for this case to get to a jury on the Daubert issue is that this patient, more likely than not, would have survived if she got an antibiotic on March 31st. This information that was delivered to Dr. Delamata on March 31st was at noon. We know she was in at least the late catarrhal stage because that's what all the plaintiff's experts have said. She's gone within, I think it was 4 to 6 hours of that initial presentation. So the whole case is about, did she get an antibiotic on March 31st, day one? There's only about 12 hours left of day one. But what the plaintiff's literature, Dr. Snow, Dr. Amawi in particular, because obviously that's where we're headed. We haven't heard much about Dr. Pentosky or Dr. Hall. I think that's for reasons that is self-sufficient. All they ever said was earlier the better. Their opinions were appropriately not permitted, which is why the plaintiffs ended up with Dr. Snow and Dr. Amawi. Second chance. Let's try to get this to a jury. But the articles that they've got and they're relying upon are really talking about morbidity, not mortality. What those articles talk about is, with the use of this macrolide antibiotic, which is exactly what you've got to use with pertussis, we're reducing the severity of symptoms. We're not avoiding death. This case is about avoiding death. None of their articles are about avoiding death. That's what this case is about. I would submit to you that especially with respect to Dr. Ramawi, I did want to point this out. He says he's treated these 30 patients who he gave antibiotics to at some point, but he didn't know they had pertussis at the time. Dr. Ramawi is not a pediatric physician. He's not a pediatric infectious disease physician. He can't treat pediatric patients in his hospital. He never gets a phone call from the emergency department when there's a sick kid in the ER. He is not qualified to discuss a pediatric infectious disease like pertussis in this case. He doesn't have the experience. The judge got it right here. The trial court got it right when he said none of these experts were qualified. There were 7 experts originally. 2 ER docs tried to give causation opinions. Trial court said, no, that's certainly not good enough. They had 3 other experts in the 2023 order, Dr. Penkoski, Dr. Hull, Dr. Macklis, who we're not even talking about because he's not at issue in this appeal. The trial court said none of them got beyond the Gooding standard. None of them got beyond more likely than not. And they had 2 more chances. And then the judge said, you know what? They can't meet Daubert. They're not sufficiently, reliable. They're not sufficiently reliable information, despite 20 different articles. 20 different articles. It's not good enough. And that's what he said. That's what his order says. There's an interesting quote from McDowell, which I know Mr. Richardson says, shouldn't really apply here. Those experts, all they said was earlier the better. No, they had way more than just earlier the better in their testimony. They had some qualifications, but it wasn't enough. Just like here, it's not enough. So I'm going to tell you what I think the new quote should be. I'm taking it partly from McDowell, but I'm using words from our case to demonstrate to you why I think McDowell controls here, why I think the timing is the most significant issue. And this, I believe, should be the quote. We agree with the district court that the testimony essentially boils down to an opinion that earlier antibiotic treatment would be preferable. The experts then made the leap from the presumably accepted scientific principle to an unsupported scientific principle that the delay of more than 12 hours caused the baby's death. This leap of faith was supported by little more than the fact that the earlier treatment begets improvement in symptoms. The experts, however, provided no existing research detailing the mortality at different time intervals. The plaintiff has offered no reliable evidence that earlier antibiotic treatment would more likely than not have prevented the death. I suggest to your honors that is precisely the language you should use in determining that the appeal should be denied. Thank you.
Thank you, ma'am. Counsel, you have 4 minutes, 14 seconds left for rebuttal.
Thank you, Judge Stout.
Yes, sir.
I want to start with the idea about gaps. The cases stand for the proposition simply that there can't be too great an analytical gap between the data and the conclusions. It doesn't say there can't be a gap, it just says it can't be too great. Here we have studies that stand for the proposition that the administration of macrolide antibiotics in the catarrhal phase, as I said in my initial presentation, are effective in the treatment of pertussis in infants. The studies do say that. Maybe not every study, but some of them do. And then the gap can be filled with the experience of the experts. And Dr. Snow and Ruame, in this rare disease, have treated several of infants with pertussis. And there are cases that, recognizing rarity of a disease presentation, the recognizing that expert can be qualified even if they only have a handful of experiences. So there's one case in particular, and we have a lot of cases that we cite in our papers, so I just want to direct the court's attention to a few of them. McBride is one. Then another was Wendell. That was the reversal of Daubert exclusion. That's from the Ninth Circuit. And then a couple others are Cannon Carroll from the Third and Kennedy from the Ninth. And if you read these cases very carefully, I think you'll find that we don't require under Daubert this exceedingly high standard of qualification, especially with rare disease presentations. And I know opposing counsel said this isn't a particularly rare disease, but I think all the experts did recognize that, and if it weren't a rare disease, we wouldn't be hearing about pertussis outbreaks right now and how alarming that is. That's because, as our experts said, vaccines typically prevented this illness, but lately there's been a resurgence.
Do you want to respond to the last argument that the literature went to morbidity and not mortality?
I don't think that's true. I think it does go to mortality as well. But even then, again, the standard is that there can't be too great an analytical gap. So you can have, I think, literature that stands for the proposition that it reduces the severity of symptoms or it clears the carriage of bacteria. And then the experts can say, and in my experience, I have seen that the administration of the macrolide antibiotic is effective in the outcome of specific pertussis cases. So that's why I just wanted to focus on the too great an analytical gap point. And finally, actually I have two more points. Toxins. That is perfect cross-examination, Grist. If they want to get up in front of a jury and cross-examine our experts and say, do you know what the toxins do? Did you account for this? That's something that goes to the credibility or the weight of the expert's opinion, and it's a perfect jury argument. Additionally, Judge Stout, you emphasized shaky yet admissible evidence. My position is that our experts provided more than shaky evidence, but at a minimum, it certainly is shaky and enough to get to a jury. And for all the reasons that I've discussed and in the briefs, we ask the court to reverse the summary judgment and the orders and just let us get to a trial. Thank you.
All right, counsel, thank you all very much for well-prepared, well-presented arguments. We will stand adjourned.